Couple people coming in. Madam Clerk, please call the roll.
Senator Alvarado.
Here.
Senator Harper Angel. Senator
Present remotely
McDaniel.
in the district.
Thank you. Senator McDaniel. Senator McGarvey. Senator Schroeder. Senator Southworth. Senator Storm. Senator Thayer. Senator Wheeler. Senator Nemus.
Present in the room.
Senator Mills.
I'm here, and we have a quorum. And the speaker just walked in. The president is here. We're going to do House Joint Resolution 77 first, if gentlemen want to come to the table. Try to honor y'all's time, and you're busy today.
Good morning, Mr. Chairman.
Good
Members
morning.
of the committee. Good to be back with the committee this morning. We are here to present HJR 77, and this deals with governor's executive orders that have been put in place over the past year, and an acknowledgement, of course, that the court has enjoined Senate Bill 1, Senate Bill 2, and House Bill 1. We understand that those decisions will likely be made after we leave here. Some of of course, much of the conversation has been about our disagreement with some of those executive orders and some public displeasure with some of those executive orders. This does not speak to those. This really speaks to the fact that there are some of those executive orders that are and are very good for businesses, for individuals, that people don't necessarily think about in normal course of business, whether that be people that have professional licenses that have been given extensions, continuing education, things like waiving copays on vaccines and COVID testing, things that people are reliant on, and especially businesses as they are trying to plan in this very uncertain time. I think that it's important that we signal to them that regardless of what the courts say, we're going to give you at least 60 days, as it was originally drafted, 60 days to make those decisions on those certain items that we're extending that benefit you. There's another section of the bill that deals with professional boards. That portion extends everything for 30 days, just saying that beyond that 30 days, you have to go back through the regular regulatory process that we set forth in the legislature for doing administrative regs. That's really all the bill does. I do think that there's a committee sub which changes those dates a little bit.
Yep. There is a committee sub. Is there a motion to pull that for us? Have a motion second from Senator Alvarado. Okay. Go ahead, gentlemen. Mr. President.
I would just say this.
Sorry. All in favor of the committee sub, say aye. Aye. Okay. There you go. Now it's adopted.
Mr. Chairman, members of the committee, the speaker is exactly right. We have been working on this between our respective offices to make sure that the governor has the utmost latitude on these areas that we feel appropriate. We also have, there was some technical matters. That's just some dates and things of that nature that were corrected in the sub. The other is we want to make sure that this does not in any way restrict us from receiving federal funds. As it has been discussed, I think, in both chambers and quite prevalently in the news, we just wound up with $2.4 billion in our lap. So we want to make sure that we can continue to access those, because that will be close to a 14-month period that we'll be receiving those types of funds.
Any questions or comments from the committee? Senator Alvarado has a question.
Thank you, Mr. Chairman. Gentlemen, thank you very much for this. Has the governor reached out to either of you to request this?
No, this is the evolution of this, Senator, is during the court proceedings. Judge Shepard himself, actually, when he issued the injunction, suggested that perhaps we should get together to try to settle this, to work things out. The President and I sent a letter, I believe it was in February, to the governor asking for some dialogue about which of these orders he would like to extend and how much flexibility he would like on those. Responded in a manner that didn't really give us the opportunity to have those discussions about individual orders. So this kind of became our vision of what we thought that was important to continue, regardless of ultimately what the courts did.
Senator Alvarado, that is correct. This was, I think the court basically was pushing us to have discussion, asked that the governor file all the executive orders and regs into the court so we would know what was currently active, because there weren't good records on a lot of these things. And so this was done, and I agree again with the speaker. This has really been an effort for us to sift through that filing, and in conformity with the court's wishes, we came with these ideas.
Mr. President, Mr. Speaker, thank you for your leadership on this. Is kind of my point is that, again, I think we've been asking for some collaboration, clearly, and we haven't received it from the executive branch. So I want to thank you all for bringing this forward and taking the leadership to continue to extend these. I'd make a motion on the resolution.
We have a motion from Senator Alvarado. Is there a second? Second from Senator Wheeler. If there are not any other questions, Madam Clerk, please call the roll.
Senator Alvarado.
Aye.
Senator McDaniel.
Cast my vote and explain, sir.
You may.
Cast and I vote. Gentlemen, thank you very much. You've threaded an incredible needle between public safety, policy, the politics on both sides of it, the pressures we've received. It's been unbelievable. And just thank you both sincerely from the bottom of my heart for what you've done today.
Senator McGarvey. Senator Nemus.
Aye.
Senator Schroeder. Senator Southworth. Senator Storm.
Aye.
Senator Thayer.
Aye.
Senator Wheeler.
Aye.
Senator Mills.
I vote aye, and House Joint Resolution 77 passes 8-1. The same should pass on to the Senate floor. Thank you, gentlemen. Next, we will hear House Bill 261. Representative Miller is coming to the desk, and I believe we have a couple people online as well. Representative Miller, the floor is yours. House Bill 261.
Thank you, Mr. Chairman. I have online with me Kathy Rupanen of the Kentucky Retirement System, and this bill is brought on behalf of the Kentucky Retirement System. And the reason is it relates to fraud related to disability claims. The reason it's only related to KRS and not TRS or others is the richness of the disability payment in the K and the C plans. So I'd like to turn this over to Ms. Rupanen to explain the details of the bill, but it's a knowing fraud type action. Please, Ms. Rupanen.
Ms. Rupanen, if you can be
Yes.
cognizant of our time, just as quickly as possible, please.
Yes, I will be very brief. Thank you, Representative Miller. 261 amends KRS 61685 to allow for civil penalties for individuals who file false or fraudulent information with retirement systems seeking benefits, or for individuals, people, it defines people, who withhold information, records, documents, things such as that they have an obligation to provide to the retirement systems in order to receive benefits. The civil penalties that it provides for is up to 3 times the amount of benefits that were falsely obtained, $500 penalty, prejudgment interest, and legal fees and costs in litigation. Whenever these false receipts of benefits are uncovered, appeals of these matters can last 6 to 10 years in some cases. Individuals have a lot of incentive to continue to litigate these matters, to put this off as long as possible. Our current statutes do not provide for any penalties or interests. And this legislation, I believe, is necessary in order to help make the retirement systems whole when they actually recover these benefits. If they don't get the cost of litigation or interest, they're not really recovering the true expense. We also believe this could act as a deterrent to keep individuals from making these types of false or fraudulent claims. Thank you.
Motion.
We have a motion on the bill from Senator McDaniel. Is there a second or any questions? Okay, we have a second from Senator Thayer. Any questions or concerns? If not, Madam Clerk, please call the roll.
Senator Alvarado.
Aye.
Senator McDaniel.
Aye.
Senator McGarvey. Senator Nemus.
Aye.
Senator Schroeder. Senator Southworth. Senator Storm.
Aye.
Senator Thayer.
Aye.
Senator Wheeler.
Aye.
Senator Mills.
I vote aye, and House Bill 261 passes 10-0. There is a motion for consent from Senator Thayer, a second from Senator Alvarado. All in favor, say aye. House Bill 261 is proceeding on to our consent agenda. Thank you, ma'am, for your testimony and your time.
Thank you very much.
Representative Miller has the next item on our agenda, so he'll stay right in place, is House Bill 113.
And I'd like to ask
Mr. Barnes?
Mr. Barnes to the table. And this is a housekeeping bill. Now, for those of you that haven't seen too many of these, these fix things that have crept into being through the passage of subsequent statutes that slightly changes meanings. Perfect example is 258 and 258, which has already been passed, actually created a conflict with this housekeeping bill. So it's that type of thing that conflicts are created. It's been 11 sessions since a housekeeping bill was passed for TRS, so it's quite a long time. KRS, we've passed a couple since I've been in. So I'd like to turn it over to Mr. Barnes.
Thank you, Representative Miller. Thank you, Representative Miller. Bo Barnes, Deputy Executive Secretary and General Counsel for Teachers Retirement System. House Bill 113 is the TRS housekeeping bill. It is largely technical changes and does not change practice or procedure at all. There are two areas of more substantive changes. Those are, first, they put in statute stricter retire and return to work provisions for our retiring members. And these are recommended by outside tax counsel to ensure continued compliance with federal tax law. And the second area is to tighten up the disability retirement provision somewhat. And those are the two substantive provisions. They are discussed in detail in the actual analysis attached, and I'd be happy to discuss those in greater detail this morning with the committee, if you'd like. Motion on the bill.
Okay, we have a motion from Senator McDaniel, second from Senator Nemus. If there are not any other questions, the AA did not show any additional expense or any additional benefits. Is that correct? Okay. Madam Clerk, please call the roll.
Senator Alvarado.
Aye.
Senator McDaniel.
Aye.
Senator McGarvey. Senator Nemus. Senator Schroeder. Senator Southworth.
Aye.
Senator Storm.
Aye.
Senator Thayer.
Aye.
Senator Wheeler. Senator Mills.
I vote aye, and House Bill 113 passes 10-0.
Motion for consent.
We have a motion for consent from Senator McDaniel, a second from Senator Alvarado. All in favor, say aye. House Bill 113 passes on to consent.
Thank you.
Mr. Barnes, thank you so much for being here yesterday and today.
Thank you.
Appreciate
Mr.
your
Chair.
work.
It is a pleasure to see a well-run committee, sir.
Our final item is a carryover from yesterday, which is House Bill 309. And Representative Miller and Representative Nemus are back at the table. Before we get started, there was a committee sub. It is committee sub number 10, PSS number 10. Do I have a motion to adopt that? We have a motion from Senator Nemus. We have a second? We have a second from Senator Wheeler. Okay, gentlemen, if you could let us know what all the changes were. And,
I'd be happy to.
Sorry. All in favor of the committee sub, say aye. Aye. Thank you. Thank you, Senator Alvarado.
When Senator McGarvey and President James said they'd rather have nothing than what was in that bill for the subpoena power, I spoke with a business group in Louisville that had been contacted. I've had spoken with 4 or 5 times over the past 3 months about this bill and asked would they have a problem if I completely dropped Section 1. They responded to me, no, they did not. So the sub reflects that, and I'd like to have Representative Nemus talk about that, if with your indulgence.
Proceed. Yes.
So the sub knocks out Section 1. There is possibly an agreement on the framework that the House had on the subpoena. I wanted, if I could, Mr. Chairman, I wanted to say two things. One thing I've learned yesterday that supports the position that we had to go through this committee on the council, if I can just take a moment to do that.
Briefly, yes.
So the mayor has made his appointments to this committee, and there are a number of very concerning folks. A couple of them said that FOP was white supremacy, the LMP are evil and the devil, and most concerning, if that weren't concerning enough, is they said police officers aren't entitled to due process. That's the group that some folks would give subpoena power to. So we believe they should have access to subpoena power because we think that enhances the investigation. That's important. Some people think they should have no subpoena power, no access to it. Some people think they should have unfettered and unqualified. We think they should have access to it. We think that improves our community. Our community needs this, we believe. And so we've reached out to a number of people, the FOP, ACLU, Senator McGarvey, and I think we have a compromise that works if the Senate would agree to it. And that is that they still have to go through, the board still has to go through the committee. The committee would subpoena just like
Metro Council Committee.
Metro Council Committee. Thank you, Representative. And then the documents that that the committee gets back, they would then forward onto the board. Whereas before we said it was a May. I think it was not our intent to have it a May. So that whatever documents they get, remember they've already vetted, made sure the subpoena is appropriate. The elected body has. Whatever they receive, they give to the Inspector General, who has professional. He's got a professional background in investigation in this area, or he or she. So those documents would then be forwarded on. I think we've reached an agreement. I guess Senator McGarvey can talk about his understanding of that, and we also would say, because we never intended it not to be able to go after documents that third parties have. Somebody brought up tasers yesterday. When you subpoena something, it's in the custody or control. They certainly would have the control of it. So that was already covered. We thought we want to make it explicit. So with those two changes, FOP agrees with it. I think Senator McGarvey, he can speak for himself. I think he agrees with it, and the ACLU agrees with it. So I think we've reached a good resolution there. I also want to say, if I can, real quickly, because I want to correct the record on something the mayor said this morning. He's taken shots at us because we don't agree with, and even if Jerry and I, Representative Miller and I did, we couldn't get it past the House anyway. We won't agree with direct access to subpoena for this board. Even if the Senate does, and I don't know what the Senate's position is, the House couldn't pass it. So the mayor has said he thinks it should be there. I'm going to tell the truth, just straight up. A senator and I met with the mayor's top 2 people this past summer. She gave us the mayor's top 10 list. On that list was direct subpoena power. But listen to me closely here. I'll take a lie detector test. Both of those ladies told me, and this senator, this is on our list, but the mayor doesn't want it. It's bad policy. And I said, so the mayor's got something on his list that he doesn't want, and he's putting it on us. She said, you can characterize it however you want, but he's going to request direct subpoena power, but he doesn't want it. It's bad policy. I'll put my hand on a stack of Bibles, they said that, and I'll take a lie detector test. Now he's out in the media saying he wants direct subpoena power. That's not what he told me, his people's top 2 officials, and that's not what he told a leader of the Senate. I wanted to make that clear, and I hope the people of Louisville are listening, that he's telling you one thing and telling the legislative leaders from Louisville another.
Mr. Chairman, with your indulgence, he's also given the impression that we won't negotiate. I have not spoken with the mayor. Mayor's not reached out to me. His deputy mayor, the last contact I had with her was a text in January. Since the middle of the session, I've had no contact with them except through their general counsel, and I have responded favorably to some of the changes they requested. So I did not, when I started this process, I didn't even know about the CRAB. I had a core of a bill which I want passed because that's important for Louisville. We added the CRAB because we knew that subpoena power, access to subpoena power, was important to them. We knew they couldn't get direct subpoena power. I offered an avenue that was what they needed, but not what they wanted.
Right. So is the core of the bill that you initially brought what we have before us now in the
Yes.
PSS 10?
Essentially it is, although the last
subpoena power,
Yes.
which we would like to reinsert
Yes.
if the Senate would agree with that.
Right.
Well, currently, right now, what we have in front of us is not the subpoena power. We just have the stripped down Louisville bill that you initially started with.
Correct.
Are there any questions from committee right now? We have 2 or 3 people online that might need to speak just real quick. Senator Thayer.
I see the language, term limiting future mayors to 2 terms is still in the sub. And you would know, Representative Miller, because you used to be on Metro Council, is there an impeachment process for Metro Council to consider to remove the mayor?
There is a process that was set up in 67C almost 20 years ago. However, the way it's worded, it's not called impeachment, it's called a charging committee. There are 10 councilmen out of the 26 councilmen have to be on that charging committee if it's a mayor. But those people don't get to vote, yet you still have to get 2/3 majority, which is 17 plus. So it's mathematically impossible to impeach a mayor, no matter how feckless.
Well, this one's pretty feckless. I believe his approval rating at one point was 12%, and I'm not sure who those 12% were. What a tremendous lack of leadership out of that office over the last year. I'm wondering if this is something we should look at in the Metro Charter going forward. Not in this bill, not enough time, not even sure I'm going to vote for it, but just want to put that out there today. I mean, the guy came before the Agriculture Committee at what was left of the State Fair in August, completely oblivious to what was going on around him, and talked about what a wonderful food town Louisville was in the middle of the biggest crisis the city's had in 50 years. Thank you, Mr. Chairman.
We have President James on the line. President James, just a couple minutes, please.
Yes, sir, Mr. Chair. Thank you very much for your time and allowing me to be here. I am just listening to Representatives Nemes and Miller talk about the subpoena power portion and their agreement with Senator McGarvey. If I could ask a question, does that include third party or
Yes.
like telephone records,
Yes.
things like that?
Yes, sir.
He said yes.
It was always
Thank
our
you.
intention to do that, President James. We thought the language was sufficient, but we are willing to tweak that language to make it very, very clear.
All right, thank you. Senators, Mr. Chair, I would thank both of the representatives for the changes that they have made to the bill. I would still say that there's grave concern on my part and on the council's part with the annexation language that is in this particular bill. The citizens of Jefferson County when they voted for consolidated local government, for annexations to go a particular way, and that the Metro Council would decide on how that would go. The language that's been put in 309 has not been discussed here in Jefferson County amongst the citizens of Jefferson County in any debate. And I'm very concerned about unintended consequences that this annexation language could create without the privilege of having that debate and that discussion amongst our citizens and with the Metro Council members. With that, I will be quiet. Thank you.
Okay, we have, thank you, President James. We also have Kate Miller. Kate, if you have a couple minutes, I know I've skipped over you previously. I apologize for that, but do you have a couple minutes, please?
Thank you so much. My name's Kate Miller. I'm the Advocacy Director for the ACLU of Kentucky, and I appreciate the opportunity to testify before you today. I just want to keep my remarks very short, but just briefly, we, as you all know, heartily endorse meaningful oversight of all government institutions, all public institutions, but especially law enforcement, because they have such high levels of responsibility. And there are a number of reasons to support oversight, but I want to be clear that the most important reason for us is the ability to hold public institutions accountable, provide space for those who have experienced harm to find redress and relief, and for those who have done harm to make amends, because we all know from personal experience that that is the only authentic way to build trust. And so with that in mind, we ask you to move forward with the proposal to establish a civilian review board that empowers that board with the most robust access to records and witnesses as possible, the most robust access as possible. And with that in mind, there were a couple of examples given, so I'll give a couple myself. You know, when this body, this chamber, discussed civilian review boards last week, there was a hearty discussion on the sexual assault and sexual abuse perpetrated by LMPD officers against Louisville kids through the Explorer program. And as a Louisvillian, I don't have to tell Representative Miller and Representative Mimas that was, as well as Councilman Hollander and James, that was abhorrent to watch unfold, not only because of the abuse, but because of the evidence of cover-up. But that was several years ago. Just this week, there have been 2 alarming stories on law enforcement officers within the Commonwealth. There was a story from the Herald Leader, I think last week, about an officer who used a racial slur and entered a home, even though he had been denied access to that home by his supervisor for a misdemeanor warrant. He entered the home with guns drawn. That happened in the fall, and he didn't resign until February. Just this week, WDRB reported on a story that a law enforcement officer in Louisville who was tasked as the diversity and inclusion officer for LMPD experienced discrimination, allegedly experienced discrimination and bias. And so these are the perspectives of the community that are calling out for an opportunity to hold our institutions accountable. And that's why we are asking for the most robust access that you all will permit. And we want to say, hey, look, if this doesn't work and CRB doesn't get the access they need, let's come back in 2022. We'd love to have that sort of commitment to 2022 and say, let's make sure we did this the way that it should be done. And so thank you for the opportunity to testify. Thank you, Representative Mimas and Representative Miller. Thank you, Senator McGarvey. Thank you, everyone, for allowing this space for us to be a part of. And we urge you to pass as robust access to subpoena power as possible. Thank you.
Very good. Thank you, Ms. Miller. Councilman Hollander, are you online? Just a couple minutes, please.
Yes, sir, Mr. Chair. Thank you very much. Thank you very much, Mr. Chair. Yes, sir. I have 2 comments not related to civilian review subpoena. And I would say, Mr. Chair, in response to your question, there are 2 sections of this bill which were clearly not part of the original legislation. And those are the sections that deal with annexation. The section allowing suburban cities to annex without any approval of Metro Council, which is a direct contravention of what is approved by the voters, was not in the original legislation. It appeared on the House floor. The section that allows new suburban cities to be created was not in the original legislation. It appeared yesterday in the committee substitute. When Louisville voters voted for a merged government, we voted to abolish the city that I lived in, the city of Louisville, to allow suburban cities to continue, but to say that for 12 years they couldn't expand. And when they did want to expand, and they have since then with Metro Council approval, it would take Metro Council approval. That is being stricken from the law that the voters of Jefferson County approved. We also said that having 80 plus suburban cities, we weren't going to allow more. That is also being stricken from the merged government that the voters of Jefferson County approved. There's been no discussion about that in the community. No discussion among the people who supported merger. I've talked to GLI today. They have no position on this because they've never heard about it. They were big supporters of merger. We have talked about annexations at Metro Council in a very bipartisan way, and this has never come up. One of the first things I did on council was to vice chair a committee chaired by a Republican, Kelly Downard, talking about annexations and how we could deal with it. It never came up in that discussion. We just changed our ordinance as to how we would review annexations, and it never came up in that discussion at all. I don't think this is the kind of change that should be made to our merged government that the voters of Jefferson County approved without any discussion in our community. I have one other comment. Page 10 of the bill strikes language of 65.0037. 65.0037 allows the Metro Council to delegate existing subpoena power to the Ethics Commission. I don't understand why we would be doing a bill which would say that our Ethics Commission would no longer have subpoena power. And so I don't know if that's unintended by the sponsors, but that is in this bill. It's on page 10, striking the language 65.0037. And that's exactly what 65.0037 does. Thank
Very-
you, Mr. Chair.
Very good. And one more, Miss Hopkins, if you have a couple minutes here, then we'll return the discussion here to the room. Thank you.
Thank you, Chair Mills. Yes, a couple of comments, and thank you, Councilman Hollander, for making the point about the ethics provision. We have made that point before. Holly Hopkins with the Jefferson County Attorney's Office, Legislative Services Chief, and our office also handles all the litigation for Metro government. With respect to civilian oversight, if I understood correctly from Representative Miller and Representative Nemes, the committee substitute before you, which I have not yet seen, strikes out existing section 1. However, there's a verbal agreement that will later come to paper that was articulated on the record. Did I understand that correctly?
Ma'am, the only thing in front of us right now is just the committee substitute. There's been testimony that there is an agreement on Civilian Review Board panel, but what we're considering right now is the committee substitute, which takes out section 1.
Thank you. Thank you for the clarification. So I will direct my comments then to the settlement provisions that I mentioned yesterday. These provisions have been in the bill for some time, and I commented on them before the House committee and have commented on them to other individuals. As written, a committee of Metro Council would be required to approve before making an offer any settlement offer in excess of $1 million. The effect of that language would be likely Metro would lose its insurance coverage. Those of you who are lawyers and deal with litigation know that third-party coverage, you want to access that coverage, you give control of the case to the insurer. Simply put, if the entity with the financial exposure can't control the risk by making the decision, whether and for how much to settle an individual claim, there's little incentive for them to provide that coverage. Insurance contracts require that you give the insurer the control of the case. They need to be the ones to make that decision. The contract requires that they are the ones to make that decision. In addition to our third-party excess coverage in Metro government, we are part of an insurance trust. Several local entities contribute to this trust, and the 4 largest, which include MSD, TARC, the Housing Authority, and Metro, are the board members that evaluate requests for claims against the trust. Again, the board controls because the board's funds are at risk. The contributors' funds are at risk. If Metro Council then gets to make decisions about what is approved and for what amount, the other contributors to the trust have no incentive to join because they have no control over their funds. This puts insurance coverage for Metro government at great peril. It also creates practical barriers to settling cases. Anybody who's been involved in litigation knows how free-flowing and fast-moving settlement negotiations can be. And to have to go before a public body to get approval before making an offer creates practical barriers to having settlement approved. It becomes even more problematic in the context of court-ordered mediation. You have to be in a room with the powers that be and the authority to do it. This bill constricts that authority, and we think these provisions are very problematic for Metro government. Frankly, the effect would be we would probably wind up having to try every case over $1 million.
Very good. Senator McGarvey.
Thank you, Mr. Chairman. Thank you, Representative Miller and Representative Nemes. The subpoena power is not at issue in this bill, so I'm not going to spend a lot of time talking about it today. But if it gets back in this bill, this is the type of bill I would love to see go to a conference committee. I think there have been some really good conversations since the committee hearing yesterday, And if this could get to a conference committee, this is the type of thing where maybe we could work something out and get something good for the people of Louisville. So I want to go through the bill that is in front of us today, and you've heard a lot of these points, but I want to give it to you from another Louisville legislator's perspective. This deals with local government, and we are telling local government what they can and cannot do regardless of whether they've asked for it. For instance, the settlement on page 5 of this bill. You just heard Ms. Hopkins go into some detail about this. I want to give you a very real world example of what just happened. The Breonna Taylor case was settled for $12 million. And there was a lot of uproar when that happened. Some people were upset by that amount. Now we see just recently that George Floyd was settled for $27 million. Well, if this bill had been in place, then the mayor, whoever the mayor would have been, couldn't have settled that lawsuit for $12 million. If it had gone to trial and a jury had awarded $25 million, the city's insurance company could have come back and said, we're not on the hook for $25 million. We could have settled it for 12. You guys are the ones that chose not to settle it. And so there really could be some real world ramifications from getting rid of this settlement power from the mayor that have nothing to do with partisan politics whatsoever, just working on how you actually settle cases and run government. I want to talk about the term limits. I think it's long past time we had a conversation about term limits for all offices in this body. But this bill just term limits the mayor. I ask a rhetorical question. Let's say that all of the events of the past year had happened in the mayor's second term. Does anyone think they would have been handled differently? We're limiting one office in one county even further. And by the way, that office is already term limited. But the people of Louisville voted to have that term limit in place for that office when they voted for merger. They knew exactly what they were going to get. They were going to get a mayor for the entire county of Jefferson for 3 terms at a maximum. We're coming back in here because we don't like the decisions of one mayor in 1 year and limiting terms. Maybe it's the right thing to do, but let's have a full-blown discussion about term limits. And I ask you guys, how would you like it if we didn't like something your county judge did and just came into Clark County and said, we're going to limit the term limits of your county judge and your county judge only from state government? Let's have a real conversation about term limits. A lot of us have been pushing for it for a long time. This doesn't get us there. The annexation piece, you heard Councilman Hollander talk about this. And Councilman Hollander, good to see you. I should say he is a constituent, full disclosure. But he's not my councilman, but I'm his senator. And he's right. We haven't talked about this. Could this end up being a good thing? Maybe. But we have no idea the ramifications of what this means long term. What we do know is it does look like it could potentially unwind much of the agreement of merger, where the cities were frozen and the consolidated urban services came in. Again, that's what the voters voted for. If this is something that needs to be done, let's talk about it. We have a state and local government committee that works on these local government issues with the cities impacted by them. I don't want to be completely negative. There is a really good part of this bill, and that is the Metro Council deserves its own legal counsel. I fully support that. But it's mixed in with a bunch of other stuff. And we're not talking about civilian review boards anymore. We are just talking about the substance of a bill which could drastically alter the form of government put in place by the voters of Louisville. And we're doing it on basically what I call the last day of the regular session before the veto on a committee sub that is the 10th version. And while I'd like to see a lot of this go for a conference committee, I don't think this bill is ready for prime time for the reasons I've laid out for you guys. And then, of course, the reason I didn't even know about until today, that 65.0037, that we're now taking the subpoena power away from our ethics commission. Something, again, I don't think has been fully fleshed out or maybe was even intended. So I have some problems with this bill, guys. And I ask that you think about your own local communities when you're voting on this bill. And if this is the kind of thing you'd like to see for them.
Senator Thayer.
Thank you, Mr. Chairman. To be fair to my friend Leader McGarvey, Jefferson County and Fayette County both asked for and received a different form of government than 118 other counties. And when you ask the legislature for special dispensation, the legislature has the right to come back and make those changes. Now, I just say that from a general point of view. Doesn't mean I'm going to vote for the bill, doesn't mean I'm going to be against the bill. But this legislature has certain rights to make changes to the form of government that are in Fayette and Jefferson that are different from all other 118 counties. And so we have the right to make those changes. That's all I wanted to say. Thank you.
Very good. Any other comments from the committee for us? Any other summations from the representatives before us?
Thank you, Mr. Chairman. Certainly, I'm not sure, but I will check if it does inadvertently remove subpoena power for the Ethics Commission. But believe me, I've been trying since 2016 to get direct subpoena power for the Ethics Commission, and it was Mayor Fisher who blocked that in 2016. We were able to get it in 2017 via the GOAC committee, which is exactly where it should be. So I'd be happy to have a floor amendment to fix that if indeed it needs fixing. Regarding the rest of the comments, settlement agreements are approved by legislative bodies in Kentucky since at least 1917. And I've spoken with city attorneys elsewhere, and this is normal, even if you have a trust. Our county attorney takes a certain position when it's convenient for the mayor, and that's certainly why Metro Council needs its own council. So, thank you.
Mr. Chairman, in 10 seconds, I'd ask for the committee to vote this out of committee, and let's move forward. It's a good bill at its heart. I think it needs to move forward. If we need to make changes, we will throughout the day.
Motion.
All these issues have been in the community for a long time.
Okay, we have a motion from Senator Nemes, a second from Senator Wheeler. If there are not any other comments, Madam Clerk, please call the roll.
Senator Alvarado.
Explain my vote, Mr. Chairman.
Yes, you may.
I'm going to cast an aye vote to get it out of committee. I mean, there's still a lot of discussion around this, obviously a lot of worries. I appreciate the section that was removed. That gave me a lot of angst because I was probably a no on that just based off of that yesterday. So the fact that that came out makes me feel better. And I know there's a lot of work. It's out of my district. I know it's an issue that's more of a Jefferson County issue, but I know there's going to be a lot more discussions probably going on today. But I'll cast an aye vote. Thank you.
Senator McDaniel. Senator McGarvey. Senator Nemes.
Aye.
Senator Schroeder.
Mr. Chair, explain my vote.
Yes, you may.
I'm going to cast an aye vote as well to get out of committee. I do, as a person that usually values local control, I say usually because there's always exceptions, but the mayor term limit does bother me. However, Senator Thayer does bring up a good point, but that is an issue that I'm going to continue to look at. So I vote aye today.
Senator Southworth.
Explain my vote, Mr. Chairman.
Yes.
This might be the only time you hear me say this session. I'm going to vote yes to get it to committee to move it forward. I think the free conference committee is about our only option here because this thing's been the worst tangle ever. And I could sit here and vote pass. I could vote no. Certainly wouldn't vote a wholehearted yes, but I do think that if we could have the Jefferson County Louisville Metro Caucus get together and tell me what in the world's going on, I would really appreciate one clean version, and then I will vote on it with my eyes and my heart. Thank you.
Senator Storm.
Explain my vote.
Yes, you can.
I'd like to vote aye today to get it out of committee, and I think there's some issues, obviously, that need to be worked through, and I appreciate your ability to work on those issues.
Senator Thayer.
Explain my vote.
Yes, you may.
I'm going to vote aye to get it out of committee, and I rarely do that, but I have a lot of respect for the two men sitting before me. I don't like civilian review panels. I think, as I said yesterday, we have civilian review panels. They are called the elected bodies of government, and they should be the ones dealing with this, not an appointed, unelected board. Also, I'm ambivalent about the term limit piece. I just think we need to give Metro government a better avenue for impeachment to remove for misfeasance, malfeasance, nonfeasance, or however you want to ascribe Mayor Fisher's job performance over the last year or so. On the term limits matter, I'm old enough to remember when they called Jerry Abramson the mayor for life. I mean, he was on Maker's Mark billboards, for heaven's sake. I don't know if this bill is going to come to the floor for a vote, guys, but we'll get it out of committee today. So I vote aye.
Senator Wheeler.
Mr. Chairman, explain my aye vote.
Yes, you may.
Again, I'm going to vote yes to make sure that the conversation is continued. I have great faith in the two people sitting before me, as well as other members of the Louisville legislative delegation. I think that a conference committee where these things get hammered out is the appropriate place for that to happen. So I'm going to vote aye to move it forward.
Senator Mills.
Yes, explain real quick. One of the reasons I put this on the agenda was to give some oxygen to this. I think there's been a lot of work on both sides, and I think we've done that today. So I'm going to vote yes to move it on out of committee. So House Bill 309 with the committee sub 10 passes 9-1, and same shall pass on to the Senate floor. Thank you, gentlemen. If there are not any other items